Alright Doug, I have sent off the application for leave. For case 40702, Quebec versus Griffith, until we receive correspondence from the respondents.
Great Kathy, we will reconvene with this case in the coming months. Continue on with your next assignment.
It looks like I have just enough time to take our interns on the next tutorial. This is case 35201, Loyola High School versus Quebec. We will be heading down to the courtroom in B building, but before we do I'd like to briefly go over the facts of the case. Quebec has a history of plurality in both criminal and civil law. This includes the education system. After the emancipation of France by the British, the Church occupied civil law and education in Quebec. Long before, but especially after the Duplessis orphanage occurrence, a subsequent secularizing of education and religion in government became of popular demand in the province. When it comes to freedom of religion and secularism in Quebec, a balancing act had to occur. Quebec government, no longer under the guise of the Roman Catholic Church, gave Catholic presence in the private realm, including the rights to private schools. Quebec's Supreme Court cases have become a pinnacle reference due to the shared occupation of Quebec as both a secular province and a province of many religions and cultures. Legal issues. On the behalf of the appellant Loyola High School, their issue with the Minister of Education was his professional stance and posture. And as a traditional school of Catholicism, they argue that the ERCP neutrality clause forces a traditionally religious institution of the people to teach from a completely neutral stance, arguing this is an infringement on their institutional right of freedom of religion. On the behalf of the respondent, the Minister of Education feels that the merits of the ERCP are such that it would be an infringement on other religions to teach the program from an entirely Catholic perspective. Therefore, necessity of neutrality is critical, and thus not an infringement of Section S15(1) of the Charter. Now, follow me to the courtroom. Let us get down to the main questions. The court's reasoning and the outcome of such reasoning considering the main questions. Of the appellant Loyola High School, the denial of their two applications for allotted exemption of the ERC, requesting and outlining a program of the design that utilized all the ERC content, but taught it from a Catholic perspective, as opposed to an objective and neutral one as outlined in the ERCP. They felt denying them to act on the Catholic traditions was an infringement of their charter rights S.2a. On behalf of the Minister of Education, Sports, and Recreation, the Minister denied the application twice since the main tenet of the ERC program is the neutrality of the delivery, by instructors. The ERC program is a government-mandated program. Its goal is to raise awareness of religion and cultures of all others, as found in Quebec's diverse society in all public and private schools. The objective of the ERCP is to supply students the ability to understand religious culture, which includes the study of world religions, the ability to reflect on ethical questions, and the ability to engage in dialogue, is crucial. To achieve its goal, the recognition of others, and the pursuit of the common good. Alright interns, let's test your review. I need 4 people to each give me one of the 4 main questions of the case. Yes. Manoj, please provide us the first question the courts would need to ask.
The first question the courts would need to ask is Loyola, as a non-profit religious and private institution, protected under the Charter S.2 freedom of religion? The reason the courts need to ask this is that Loyola is claiming an infringement of religion. They also need to determine this if they are to utilize administrative law such as Oaks or DAW.
Yes, that is correct, Manoj. Great explanation. I like the way you highlighted the necessity of administrative law relying on discovering whether or not an infringement has occurred. In the High Court, it is very important that the judges go over all the previous court's decisions and questions with a fine-tooth comb. This means oftentimes repeating past decision steps. Alright, who would like to express their knowledge on question number 2 of the High Courts?
I can take a stab at it. The next question the High Court should be asking is, if the ERC program and its contents, expectations and objectives of neutrality, are infringing on the religious rights of Loyola as a private Catholic institution.
Excellent, Jasmine. Okay, number 3, who's up next? Kyle. Go ahead, Kyle. Enlighten us on the third question of the High Court in this case.
I think it's important for the third question asked by the High Courts to be based on the assumption that an infringement actually did occur. Therefore, the question is, did a literal S1 approach for robust proportionality analysis of the infringement determine if a minimal impairment of the charter in question has occurred? If it is an actual infringement, it cannot be held by the court as appropriate, and thus question 4 would need consideration.
Certainly. I like the way you frame that question. Alright. Before we run out of time, who would like to take the last question? Go right ahead and just shout it out. And then we will move on to the court's answers and their reasoning for these answers.
If an infringement has been found to be of inappropriate proportionality, and thus an inexcusable violation, I believe the courts would then ask, if infringed beyond a minimal degree, then what would the ERCP and the Loyola outcomes have to look like? In a balanced proportion, a balance must be found that satisfies the proportionality test and the door test.
Fantastic, Madonna. I must say I am impressed. Well, I'd say we established the necessary questions. Now let's look to the reasoning for the courts. Some main cases that helped them determine these reasons. Outcomes of the reasoning and ultimate decisions. When the courts are determining the answer these questions. Essentially the charter right depicting freedom of religion. The High Courts must utilize past case outcomes to determine whether an institution is considered protected by the charter right of the freedom of religion. Whether the ERCP infringed, and if so, to what degree. There have been multiple cases in history of the Supreme Court in Canada, as well as abroad, that have concluded that due to the protection of the rights of individuals under freedom of religion under Section 2 of the Charter, the institutions of religion must be protected. The courts also decided that due to Loyola faithfully attempting to adapt to the confines of the ERCP objective, and the minister not budging, they considered that the infringement was beyond minimal. Once they decide this, they prepared an exception on the behalf of Loyola. Loyola should be able to teach any Quebec history, as well as any Catholic religious content from a Catholic perspective. The courts decided a proportional balance for the ERCP can request the objective of neutrality for all religions outside the Catholic faith, Quebec history, and ethics of the like. The Supreme Court finalized this hearing with the new clause for private schools in Quebec. The secularistic neutrality of education in private schools is limited by the Charter of Rights and Freedoms S.2a. Doug, I have finished the closing arguments with the interns. I have 83% pass rate from the next module. I think it is important to have more time for the deeper speculations of each case and how it weighed, as well as the factors of decisions in the cases that propelled them into utilizational significance for the High Courts.